following President Muhammadu Buhari's rejection of the Electoral Act Amendment Bill. All eyes will now be diverted to the National Assembly to override its veto. But only a few are confident that Nigeria's rubber-stamp legislature, led by Dr. Ahmad Lawan, can muster the two-thirds majority required in both houses to override the president. Weighing in on the issue yesterday, Governor Nyesom Wike of Rivers State said the National Assembly lacked the temerity to overturn the presidential veto. Given reasons for his position, Wike explained that it was part of the scheming of the ruling All Progressives Congress to deny Nigerians free and fair elections in 2023. He said it was obvious to him and all discerning minds that a clause on direct primaries was inserted in the bill as a ploy for President Buhari to withhold his assent to the legislation. According to the governor, APC members were afraid that if results were transmitted electronically, the ruling party would lose badly in 2023. So they decided to amend the bill to provide for only direct primaries, knowing that the president will use this as the perfect fodder to reject the bill. Now joining us to discuss the legislative and political fireworks expected to ensue after the rejection of the Electoral Bill is Norrison Quakers, a senior advocate of Nigeria. Good morning, Norrison, and welcome to the show. Hi, Norrison.
Dr. Abati.
Good morning.
Good morning, Rufai.
Good morning,
OJ.
Yes, well, you didn't call like Genix or
Compliments of the season.
Same to you. Same to you. Good to have you on the program. Well, very quickly. In the introduction, I was drawing attention to a certain conspiracy theory being pushed by the governor of Rivers State that, look, this was foreseeable, that this was premeditated, the outcome, that is, with regard to the president refusing to sign the Electoral Act Amendment Bill 2021. I would like you to comment on that conspiracy theory. Was this really rigged to fail the way it has? And secondly, what do you think should be the next steps, given that this is also a constitutional matter? Section 58, Section 59 of the Constitution in the appropriate sections.
Thank you so much. I wouldn't subscribe to the conspiracy theory being propagated by the executive governor of Rivers State. Incidentally, the way the Constitution is couched, it has already provided for a situation such as this. When a bill is presented to the president, the executive, there are two things that can happen. It's either he assents to the bill or he withholds his assent. And that you'll find in Section 58, sub 4 of the 1999 Constitution as amended. Now, 58.5 is the one that now states categorically that where the president withholds his assent, the bill will be passed by two-thirds majority of the two legislative arms of government. Now, the issue I think we also need to look at and address very clearly is that there's a time frame, a 30 days window given to the president to either withhold his assent or to sign the bill into law and then forward it to the National Assembly. Mind you, there's also a presumption. I recall somebody said sometime back also on this program that the Nigerian Constitution is a creation of the military, and so there is no impute that was made by the Nigerian people or the Nigerian public. And it says we, the Nigerian people, we were never consulted. Well, that might be true to a certain extent. But the question is, do we have representatives that we have voted into the legislative arm of government? The answer to that is yes. So there's a presumption that we have representatives who are to do what can be considered to be in the best interest of the Nigerian people and the Nigerian public. Now, the bill that has been presented to the president, if you look at Section 58, sub 4, it talks about presentation of the bill to the president for his assent. Within 30 days, the president must act. Now, there's a presumption that that bill that has been presented to the president for his assent is for the interest of the Nigerian public. Now, what are the issues or the complaint that the president has concerning the bill? apart from what he has just stated now, that the reason why he withheld his assent is as regards direct party primaries, and explain the problem involved. And I'm happy listening to you, Dr. Abati. It's the Constitution itself, it's also a living document, just like the Electoral Act. It has been amended severally. Now, a law that is not amendable, or that is not subject to amendment, is a draconian law. We're in the democratic process. Now, if the law works for a while and certain things are seen to be wrong with the law, it is then now subjected to amendment. And I recall very clearly when President Goodluck Jonathan, before he eventually became president, when the issue of transmission of letter became an issue, that when the president or the incumbent in office leaves for some reason, he ought to transmit a letter to the National Assembly. That wasn't done when President Yar'Adua was in office, until eventually he died, and then the Constitution was now amended to reflect that. So it's a work in progress. My challenge and my worry in all of this is that there are clear and unambiguous provisions of the Constitution. It might not be a perfect document. Indeed, it is not a perfect document. It's a work in progress. And I remember Mr. Fidelis Wadialo saying a while back, of blessed memory, who said, our problem is not in the ones of rules, in the ones of legislation, in the ones of regulation. It's just our attitudinal disposition to ensuring that these things work. If we don't have faith in these documents, the documents won't work. And so that's actually where the challenge is. And so for me, the excuses that have been advanced by the president, should I use the word unreasonable and can't hold water, complete nullity. I don't want to use words stronger than the ones that I've used, and I feel so pained that at this stage of our political evolution that we're coming up with such is the provision of the law in relation to direct primaries. Is it for the good of the Nigerian people? Is it for the interest of the Nigerian people? If the answer to that is yes, flowing from the fact that it's been worked on, inserted by presumably representatives of the people in the National Assembly. So why would the president withhold his assent? He's even expected to have even done the consultation within 30 days. He has exceeded the 30 days given to him. What should the National Assembly do? Because it's already provided for. It's just simply to go ahead and is it possible to have the two-thirds majority of the House? If the answer to that is yes, then go ahead and just pass it. But the challenge is along political party lines, and so it might be a pretty difficult. You have a Senate president who once was quoted as saying that if he had his way, the president should have a third term. And that's, for me, is really sickening. So do we have confidence with this present National Assembly has considered? The answer to that is no.
Right. Well, I guess everyone wants to know the way forward. Now, can the National Assembly bring in the doctrine of necessity to amend the bill, maybe by adjusting it to address the concerns of the president? As you know, one of the bigger issues that this new electoral amendment bill seeks to resolve is the use of modern technologies in an electoral process. Now, how can the bill be saved to ensure electronic transmission of results in the upcoming election?
Incidentally, the umpire for the election, and that is INEC, was invited by the president, consulted INEC. The National Assembly was to invite INEC, but declined inviting INEC to speak on this issue of electronic transmission of results. Now, my take in all of this is that if the umpire says, look, despite all the challenges, we're able to work within the parameters of whatever is available for us. Now, recall that just yesterday, the chairman of INEC presented a budget of about 305 or 308 billion, the cost to organize the election. Now, it is the responsibility of the executive to ensure, since the president has already flown the kite, that he's going to leave free, fair, and credible election. That will be his legacy, his gift to Nigeria when he leaves office come 2023. Now, this issue of provision as regards electronic transmission of results will not even be an issue. It's been done to a large extent in Anambra State. We only need to fine-tune. You cannot, the National Assembly right now as it is deemed to have considered all of this when he presented the bill to the president for his assent. Failure to assent to the bill, the National Assembly should go to the next level and not to tinker with the provision in order to accommodate the interests of the president or the fear that has been expressed by the president. There's no such provision in the Constitution. Mind you, when you look at the Constitution holistically from section 221 to 229 as regards political parties, you will also see that political party structure is also one that is overseen by the Independent National Electoral Commission, because it is the only body that is licensed and authorized to also issue political parties with their certificates. Are you also aware that when party primaries are conducted, INEC is expected to also be involved or supervise the party primaries, whether it is in accordance with the Electoral Act? Now, being saddled and being empowered by the Constitution to do all of this, why would the president, knowing the clear and unambiguous provisions of the Constitution, knowing the power that is vested in the National Assembly, knowing that the only umpire that can complain about any of these issues is the Independent National Electoral Commission, and it's not complaining. So why will the president now withhold his assent? I don't see the issue of electronic transmission of results as a burden, as a problem. Mind you, NCC was also consulted on this issue, and NCC also gave the green light. So what are we talking about? It's rather sad that we're still discussing. It appears that we've gone 50 years backward instead of moving forward. It's just so sickening.
A lot of people will argue that the main matter, the meat of this matter, is the electronic transmission of results. That these direct primaries or not direct primaries by parties should be their own palaver. Wasn't that enough reason for the president to sign this in the first place, then make amendments afterwards? Because when you even look at direct and indirect primaries, the America we copied this democratic form has a mixture of direct and indirect primaries. You have people from different political parties voting in the state primaries, and you still have superdelegates. So the question is, they can sort out their problem, but what concerns Nigerians is the electronic transmission of results, which we are losing here because of this smoke screen of this political gymnastics going on.
Rufai, I totally agree with you, 100%. Like somebody once said, we're operating a system we do not really understand. And because we do not have the attitudinal disposition to ensuring the effectiveness and the efficiency of the law, we will keep coming up with all kinds of excuses why this shouldn't work. Now, the question you will also ask is simply this: what is the rationale behind the refusal to sign, other than what the president has also projected? Is it in the interest of the Nigerian people, or is it self-serving? Is it in the interest of the political party? And if it is in the interest of political party, to what end and to what extent? What is the rationale? What is the reason behind all of this? So clearly you can see that whatever kite that is being flown, whatever issue that is being projected, it is not in the interest of the teeming Nigerian populace, regrettably. So I totally agree with you. There's actually no excuse for what we're experiencing now.
Okay, for the purposes of clarity, as we begin to wind down, we know the issues, we know what the facts are, we know what the concerns are out there. What specific advice will you give to the National Assembly and also to the President in this matter right now as part of next steps?
Thank you so much. Incidentally, since the president has withheld his assent as constitutionally recognized that he could do, the National Assembly should also exercise its authority, being vested with the same constitutional provision under Section 58(5), and simply pass the bill into law by ensuring that two-thirds majority of the legislative arms, the two arms, vote to ensuring that the bill becomes law pursuant to Section 58.5. But my own concern and worry is, will they be able to do that? And that is the big question mark. Because, you see, we also have a populace that is reticent. Nigerians, there are not many informed Nigerians on this issue. They're just few and far between. And that's why this has also continued to a large extent. So that's my advice. I don't see the president again reversing himself. But right now, the burden rests squarely on the shoulders of the National Assembly to do so. Thank you.
I think you've answered most of our questions. But, let's talk about this direct primary, which Buhari also noted that adopting the direct primaries also has implications on the rights of citizens to participate in the government as constitutionally ensured. What does the president mean by this statement?
You recall that PDP, as a political party, opted for the option A4. Now, the freest and fairest election that has been conducted in Nigeria so far has come by as a result of the option A4, which is, at best, can be described as direct primaries. Right? Now, if the president is saying that it will disenfranchise, it's something that strengthens democracy. Until you implement it, you will not know the effectiveness and the efficacy of the system. A lot of parties, I recall that earlier when a summary was being done by one of your, I think during the newspaper review, he did say that the reason why this has been included in the Electoral Bill is as a result of some political party members who for so long feel that governors have always had their way when it comes to candidates being fielded for election. That when you make it direct primaries, their control will have been diluted. And to a large extent that I agree. So if this is something that will strengthen and deepen democracy, so be it. So the presidents, there are pros and cons on this issue, but the law must first be passed. And then see how it works before you now start complaining. If you feel like it's not effective, then it's then be subjected to amendment.
All right, sir.
No law is meant to be static. As society evolves, you can also amend the law.
Can the words of John Locke, the great thinker and philosopher, serve as an inspiration this morning? That says legitimate government is based on the idea of separation of powers. And first and foremost in that separation, the legislative power is supreme. Can the legislative power, like in the words of John Locke, reign supreme this morning?
Absolutely. I totally agree with you. Recall that Dr. Abati, and I give that to him, identified clear and unambiguous provisions of the Constitution in relation to the three arms of government. The first arm you come in contact with is the legislative arm, and that is in Section 4. And it is the legislative arm that actually donates the power to the executive and also to the judiciary. Now, because, you see, law, as we have been taught, is an instrument of social engineering. It is to direct our affairs. So once a law is in place, the essence of all of this is that we can live in some environment of order, of peace, an environment where we're also secure. Then you have Section 5, which is the arm that deals with the executive, and then 6 in relation to the judiciary. So clearly you have defined separation of powers enshrined in the Constitution. The concept that was propagated by John Locke has now been codified. But you see, the challenge we have is you now have a group of persons who are giving legal and legislative interpretation with cultural and religious perspective and mindset. It's just a mess.
Okay, very quickly, I guess John Locke is much later than Baron de Montesquieu. But very quickly, I wanted to ask you, one concern is that, look, when it comes to direct primaries and indirect primaries, that, look, the existing framework says that the parties have the right in their constitutions and also under the Constitution to preside over their own affairs and make their own choices. So in that regard, do you think, if, as you have recommended, that the National Assembly should just override the president's veto, that there wouldn't be also some kind of chaos with political parties or some stakeholders going to court to challenge that particular aspect of the electoral law if it becomes law?
Dr. Abati, you know the beauty of constitutional democracy, like Justice Begore said, is the role that the judiciary has to play in interpreting the laws, either when they are breached or seeking interpretation or clarification of some clear or some unclear provisions of the law. Now, what is the mischief that the lawmakers were trying to cure? It was part of what we were taught when we were in school, that there's always a mischief. So what is that mischief that the law is trying to cure? Will the law as presently framed, or the bill as presently framed or couched, be able to address that mischief? If the answer to that is yes, it will have been debated. All of these issues will have been canvassed. Mind you, you have representatives in the legislative houses of assembly, in both the House of Representatives and also the Senate, who presumably are representing the people. So it will have been debated back and forth before the bill was now presented to the president for his assent. All of these arguments will have been taken to court. And then also, you cannot be a representative, you cannot be in the House if you do not belong to a political party. And I believe the reason why this is now being shut down is because of the party's position. And so if they do not uphold the party's position in relation to this, they would then be considered as embarking on anti-party activities, not recognizing the supremacy of the party. A particular senator was even quoted as saying, oh, we cannot afford to go on collision course with the president, forgetting the fact that there's a mischief that this law wants to cure. The law should be allowed to cure that mischief without more. So that's just my position on all of this.
Okay, well, thank you very much, Norrison Quakers, for joining us. Or Oji, you still have a final question for him?
Oh, no, it's okay.
Thank you very much indeed for joining us.